Last time. They have this that is five from types of companies. Now, under incorporation, we have discussed basically according to our companies that we can incorporate. We can incorporate three types of company. The three types of company. Limited. That company is difficult to share option. Three types of companies. There are three types of companies can be incorporate with another companies. Limited and unlimited. Oh, limited liability company, limited liability company, right? Unlimited liability company. Right? Now, actually, whose liability is limited? Whose liability is unlimited? We can identify two persons after incorporation. Right? A incorporated the company under the Companies Act, A private limited. So after incorporation, A is a one person, A private limited is another person. Then whose liabilities? There are two persons, right? Whose liability is limited? A's liabilities is a limited liability company. Private limited liability company. Right? Whose liability is limited? Right? Suppose A is the main shareholder of this company. Right? Whose liability is limited? Shareholders' liability is limited. Even though the company is a private limited, right? Even though it's a limited liability company, right? Their liabilities are unlimited, right? So the point of view of the company's liabilities are unlimited. Right. Company's liabilities are unlimited. Right. Only shareholders' liability is limited. Right. Okay, what do you mean by limited liability? Now, as a natural person, your liability is unlimited. As a natural person. What do you mean by unlimited liability? That is, right now, suppose you own assets value of 100,000 rupees. Right, total assets owned by you. Right? Suppose you are one. As a natural person, Amal owned assets value of 100,000. Right? He owes to a creditor called Bima 150,000. Amal has to pay 150,000 rupees to Bima. Right? So we can identify Bima with the creditor. Right? Very good. Right. In order to settle, in order to pay, right? Pay off the credit, right? Amal has a responsibility, right? By disposing all the assets of the company, or by sacrificing all the assets of the company, Amal is responsible to pay. Because his liability is unlimited. By disposing all the assets, we cannot reserve any assets and without paying for creditors. He cannot reserve. By disposing all the assets, he is responsible to settle his creditors. That is the meaning of unlimited liability. If Amal's liability is limited only up to 50%, 50,000 rupees, then the right. So if the Amal's liability is limited only for 50,000 rupees, it means Amal can reserve some assets, 50,000 rupees, without using them to settle the creditors. If his liability is 50,000 means, it means by disposing the assets, right, he is responsible to pay only 50,000. He can reserve some part of the assets without settling, without sacrificing them to settle the creditors. That is the meaning unlimited. So as a natural person, we all have unlimited liability. We cannot reserve any asset by disposing all the assets. Right? We are responsible to settle the creditors. That is the meaning. Limited liability. Right. Limited liability means we can reserve some assets without, right, using them to settle the creditors. Right. So there is unlimited. Limited and unlimited. Right. So here again we can come to this. Right. The question is whose liability is limited. As a natural person, this shareholder, the shareholder's liability is limited. But even though this company is a limited liability company, right? As the company, right? They have unlimited liability to the creditors. Unlimited liability to the creditors. It means, as I mentioned, right, by disposing all the assets of the company, company is responsible to pay its creditors. Company cannot reserve assets without using them to settle the creditors. They cannot reserve. Company can own properties. By disposing all the assets, company, it's a limited liability company. By disposing all the assets, right, company responsible to pay creditors. So even if the company is a limited liability company's liability. From the point of view of company has unlimited liability, right, towards its creditors. Only the shareholders' liability is limited. But shareholders' liability limited means they responsible to pay creditors, right, in an amount which is already invested in shares. They will lose only that amount. They need not to sacrifice their personal assets. Shareholders, they need not to sacrifice. Therefore, their liability is limited. Company's liability is unlimited. Two views, right? There are 2 points of view. One is from the point of view of the shareholder, and from the point of view of the limited liability means shareholders' liability is limited, right? They will lose in the event of liquidation, future liquidation, only the amount already invested in the shares of the company. They will lose that personal assets, right? And the company, from the point of view of the company's liability is unlimited, even though it is limited liability company. Right? By disposing all the assets of the company owned by the company, they are responsible to settle the creditors. There is the right liability of the company. So shareholders liability, company's liability. So limited liability company. Unlimited means shareholders liability. Always liability, limited liability means that shareholders liability is limited. And unlimited means shareholders liability is unlimited. Shareholders liability is unlimited. To settle the creditors of the company. Right? It means we have to sacrifice their personal assets. Unlimited liability. There is like he's like a partner of a partnership. Right? Partners, they have unlimited liability. By sacrificing personal assets, they are responsible to settle the creditors of the partnership. Right? Like the partner of a partnership, shareholders' liability is unlimited in this type of company. Right? It is very rare company formation, unlimited liability. Right? And 1 or 2 companies are not available. Incorporated as an unlimited company, but according to law, can incorporate an unlimited company limited by guarantee. Right here, shareholders' liability is limited by guarantee. So this liability is limited only up to the amount mentioned in the articles. Right? So in other words, we can say according to the articles of association of the company, right? Shareholders, don't use shareholders, right? Members, right? Shares, right? Members, they have undertaken to contribute to the assets of the company in the event of liquidation in an amount specified in the articles. Right? Then amount specified in the articles. So here also we can identify shareholders' liabilities in an amount specified in the articles. Right? No shares. The company, right? Issued by God. So here we can't say actually shareholders. Here, we have to say members, right? Members' liabilities. Members' liability is limited only up to the amount which is mentioned in the articles of association. Members' liability. They have to contribute to the assets of the company in the event of liquidation in an amount. That amount is mentioned in the articles of association. Members' liability. Right? Right. Right. So these are the Main three types of companies can be incorporated, and not registration, incorporated under the Companies Act. Right? Then thereafter, right? Thereafter, right? Limited companies, we can divide into two. Private and public. Yes, public companies, we can further classify it as listed and unlisted. Right, limited companies we can divide into as private and public. Public companies further classified as listed and unlisted. Right. Public companies, right, and public, limited private companies. Public companies and private companies. Public company means, right, it is a public company, they can, they can invite the public to purchase the shares. They can invite. There is the word, right? Invite the public. Invite the public to purchase the shares. How they invite the public to purchase the shares? Right. Advertisement. What is the name given to that advertisement? Yes, there is a advertisement. Prospectus. Don't say advertisement actually, but your prospectus. Prospectus. But your prospectus. Right. That is the privilege given to the public company. They can invite, right, by publishing prospectus, they can invite the public to purchase the shares. But when we consider the private companies, they cannot invite. They cannot invite the public to purchase the shares. Based on that, we can divide, right, this page, and we can divide companies as private and public. Then listed, quoted companies, listed and unlisted. What is the meaning of listed? Right. They can trade their shares on the stock exchange. Okay. Okay. Listed, quoted company. They can trade, sell and buy and sell. Right. They can trade their shares on the stock. Unlisted means they don't have that to give. It's unlisted. Right. Now we can identify there are 5 companies can be incorporated under the Companies Act. Listed, unlisted, private, unlimited companies limited by that. There are 5. These are the companies can be incorporated. Then apart from these companies, we can identify other 2 types of companies. One is offshore, offshore company. Offshore company. අපි ඩියුට් එකේ ඕෆ් ෂෙයාර් එක විතරද ඕ එක ඒක ඕ කරගන්න. ඕෆ් ෂෝ කම්. ෂෝ කියන්නේ බෙරළ අක්ෂර ඕෆ් ෂෝ කම්. ඕෆ් ෂෙයාර් කියන්නේ ෂෙයාර් කියනවා තමයි. That's exactly. Oof ෂෝ කම්. And overseas companies. Overseas companies. Right. Offshore and overseas companies. Offshore companies, let me consider offshore companies on the side. Offshore company. This company is registered. That is the registered. This is a company registered under the Companies Act as an offshore company. Registered. This is a company registered as an offshore company under the Companies Act. It may be incorporated. 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 Incorporated under the Companies Act, that is for Sri Lanka or abroad. Is incorporated in Sri Lanka or abroad. Incorporation. That is it with regard to incorporation. Right. This company may be incorporated in Sri Lanka as a private company, public company, incorporated or abroad. Incorporation may be here or abroad. Only thing is, it is registered as an offshore company under the Companies Act. Registered, there is registration, registered under the Companies Act as an offshore company. The very special feature is they cannot do any business activity in Sri Lanka. They cannot do any business activity. Cannot do any business activity. In Sri Lanka. Like they are doing their business abroad. With their business abroad, not in Sri Lanka. They are not permitted to do any business transaction in Sri Lanka. Right. They registered as an offshore company. But we cannot find it here, right? The incorporation may be here or abroad. And the Sri Lankan law, and then for it, you incorporate. But registered as an offshore company under the Companies Act. Doing their business abroad. Right. So that is offshore company. That is why actually two different concepts. One is incorporation. We have discussed how to incorporate a company, submit it documents, right? By documents, it is submitted. That is the way of incorporation of the company. Right. So here, registration is different. Like incorporation may be in Sri Lanka or abroad. It's registered as an offshore company. That is registration. Then overseas company. Overseas company, they incorporated abroad. Incorporated abroad. Incorporated abroad. Not in Sri Lanka, but offshore company may be incorporated in Sri Lanka. This is incorporated abroad. However, we can identify very special region. This type of company. It is incorporated abroad. Right? It has the place of business in Sri Lanka, right? Or no, after the appointed date. Appointed date means 3rd of May 2007. In other words, actually, the Companies Act is number 7 of 2007. This Act, the effective date of the Act, effective date of the Companies Act is 3rd of May 2007. Effective date, the valid date. Thereafter, this Companies Act, right, it became valid after this date, appointed date. Right? So, on or after the appointed date, it refers to this date. As the place of business. Place of business. Or an established place of business in Sri Lanka on or after the appointed date. Place of business. Or it had the place of business here. That is prior to the appointed date. Continue it up to the appointed date. Right? Place of business and the place of business. Right? Before the appointed date and continuing up to the appointed date. Right? So that is the thing. Right? It is incorporated abroad. Right? It has the place of business. It has an established place of business in Sri Lanka. Or no after the appointed date. Or it had place of business in Sri Lanka and continuing after the appointed date. That what companies are named as overseas companies. Overseas companies. Right? So that is the definition given in the Companies Act. Overseas company. Incorporated abroad. Right? Incorporated abroad. Only a place of business in Sri Lanka. Right? After the, or no after the appointment date or prior to the appointment date. Continue the place of business after the appointment. They are place of business. Right? Incorporated. That is, right, there is the, like, the company called overseas company. Overseas company. Like altogether, you can identify there are 5 types of companies, right? Recognized under the companies. Right? 5 types of companies can be incorporated. Right? Apart from that, 2 types recognized as offshore company and overseas company. Overseas company. Right? It's in clear, very simple, right? You can say, like, private company, listed, unlisted, unlimited, company limited by that. There are 5. Then, offshore company. registered under companies that incorporated in Sri Lanka also, but overseas companies incorporated in India, right, doing their business in Sri Lanka. That is the meaning with their business in Sri Lanka. Like business place means they are doing their business. Like, or no, after the effective date of the Conference Act, or prior to the appointment date. Okay. There is that board is up. Right, so altogether there are 7 companies can be recognized. Okay. When we consider the private companies, right? When we consider the private companies, we can identify main 2 features of a private company. There are 2 main features. One is they cannot invite public to purchase the shares. Cannot invite. Cannot invite. They cannot issue prospectus. They cannot invite public. And the second feature is the maximum number of shareholders is limited to 50. 50. Maximum number of shareholders shall be 50. Understand? 50. Maximum number of shareholders is 50. Right? But when we count in the 50, right, we have to exclude employees. Employees and former employees. Former employees. Employees and former employees. Right. We have to exclude these part. Employees and former employees. Excluding these, right? Employees and former employees. Employees means they are shareholders as well as the workers of the company. And we have to remove it. Right? We are counting the 50. Right? And former employees. It means they became the shareholders by the working in the company. Now their services are terminated. Right? Their services are terminated, but still they are shareholders of the company. Former employees. So we have to remove it. And maximum number of shareholders shall be that is the private company. They cannot issue shares. They cannot invite public. They can issue shares, like they have share capital. They cannot invite the public to purchase shares. Cannot be. Okay. Right. So actually, they can issue shares to related parties, not to the public. Right. Related parties like trades, family members, right? So related parties, right? Among the related parties, they can issue shares. Right? So to the public, general public. Right? And the maximum number of shareholders shall be right, excluding employees and right? Employees and women. Getting the right main two features of the private transport. There are you can recognize some other features with regard to private companies. Some other main features we can recognize with regard to private transport. One is what is the age limit of the directors of the company? Age limit. Some persons cannot be appointed as a director of a company after this age limit. What is the age limit? 20. What is the age limit? Generally, there is 70. 70. Person who attains the year of 70, then cannot be appointed as a director of a company. But that age limit does not apply to private company. Does not apply. Therefore, any person, even 100 years old person can be appointed as a director of a company. Age limit. Does not apply to private company. Another very important feature we can recognize that even that is now suppose this private company, we have discussed this under articles of association. The main objective of the company is manufacturing books. Manufacturing books. Right? According to the articles of association, right? The object of the company is manufacturing books. manufacturing goods. Right. So, now we have actually discussed what are the provisions can be included in the articles of association. Objects, what is object? Right? Provisions with regard to management and administration. Management and administration. Rights and obligations of the shareholders. Rights and shareholders, rights and obligation. Right, so any provision not violating the company. So these are the right provisions may be included in the articles of association. Right. Now, these articles of association. Right. In a private company, right, shareholders can take any decision. Even though that decision is not comply with articles of association, right? Even though the decision is not comply with provisions containing the articles of association, in a private company, shareholders can take any decision, but subject to one thing. A private company, right? These are the conditions mentioned in the articles of association. So shareholders of the private company can take any decision, right? Even though the decision is not compliant with the provisions containing the articles, by way of a unanimous agreement, right? Unanimous agreement.
Sir, excuse me.
Yes.
Sir, screen not shared.
The screen share. Screen share okay. The screen share एक बार screen share कल मेरे क्या करना senior
I think okay.
Okay, sir.
Right. Unanimous agreement. Unanimous agreement. Unanimous agreement. Unanimous agreement. By way of unanimous agreement, shareholders can make any decision, even though it is not compliant with the provisions contained in the article. Very special thing. What do you mean by unanimous? Unanimous agreement. This is an agreement in writing. Signed by who? Unanimous. In order to be the unanimous, yes, want to be signed this agreement. Unanimous means all the shareholders. Unanimous means all the shareholders. An agreement signed by all the shareholders of the company. They can sign them. So maximum number is 50. Maximum number of members is 50. Therefore, they can sign an agreement in writing. All the shareholders can sign an agreement in writing. So it is named as unanimous agreement. So by way of unanimous agreement, they can make any decision. Right? They can make any decision even though it is not applied with the articles of association. Now, according to the object clause, it says manufacturing books. That is the objective of the company. However, by way of unanimous agreement, they can engage into transaction other than manufacturing books. Not comply with the articles of association, but they can do it by way of this name, unanimous agreement. This is the special privilege given only for the private companies. By way of unanimous agreement, they can make a decision. Need not to comply with the provisions contained in the article. Understood. So this is the right very special feature of the private company. But here further it says that they can engage into any transaction by way of unanimous agreement. We need to comply with the provisions contained in the article. But there is a condition. Subject to one condition. Condition is company must be able to meet the solvency test. Very important part, right? Solvency test. Solvency test. Right. So this is the only condition to be fulfilled. If the company is able to meet the solvency test, then by way of a unanimous agreement, there is an agreement in writing signed by all the shareholders, they can make any decisions. Need not to comply with the provisions contained in the articles of association. So actually, we have discussed articles of association in the constitution of constitution, right? The fundamental law of the company. But they can go against the provisions contained in the articles of association by this by way of unanimous agreement. But only thing is, company must be able to meet the solvency test. Right? Solvency test, very important test. Right? Solvency test means, in order to meet the solvency test, two conditions to be fulfilled. Right? There are two conditions. One is the value of the total assets. Value of the total assets is greater than, right, stated capital and liabilities. Liabilities. The one condition to be fulfilled. Right? Value of the total assets Value of the total assets is greater than stated capital and liability. Right. And the next condition is company able to pay its debts in its ordinary course of business. In its ordinary. Ordinary course of business. Company able to pay its debts. Able to pay debts. So these are the two conditions to be put. If company able to meet the solvency test, then by way of unanimous agreement, private company can engage into any transaction. Even if the transaction is not complying with the articles of association, just mentioned. Right? Two conditions to be fulfilled. Now here, when we consider, we have to check whether the company, right? Now solvency test, under solvency test, we have to check whether the company able to pay its debts in its ordinary course of business. Able to pay its debts in its ordinary course of business. Actually, what, right? It refers to able to pay its debts in its ordinary course of business. Day-to-day business, company able to pay its debts. That is the meaning. They have to check whether the company able to pay its debts in its day-to-day business, ordinary course of business. So what we have to consider. Actually, second one should be the first part, right? There are two conditions. Right. What we have to check here. Day-to-day business, we have to check whether the company able to pay its debts. It refers to what? As yes, accountants, what can you say? When we consider this concept, according to the accountancy, yes. What we have to consider. Yes. Actually, here the first one, here the second one, in its ordinary course of business, they have to check whether the company able to pay its debts. That is, right? We have to check the working capital of the company. Working capital. Working capital. Working capital. So we have to consider whether the company has good working capital. Right? Day-to-day business, whether the company able to pay its debts, working capital. The first one, value of total assets greater than stated capital and liabilities. Okay. As an accountant, what it requires? First condition. Right. Now it says, now suppose this is the balance sheet. Balance sheet, total assets, contract. Value of the total asset is greater than stated capital. Stated capital 50. Right, liability 20. Then we can say yes, total value of the total asset is greater than stated capital and liability because state and capital 50 and liability is 20. Yeah. Total asset 100. 100 is greater than 7. The first condition is right able to be. Right? Then what it refers to? What is the balance? What is the difference? Shall be equal to 100. 70. What is the? What is it? Yes, what is this? Stated capital liabilities. What is the difference? Yes. Correct. 30. What is the 30? Yeah, 30. What is the is the balance sheet? Yes, 30. Balance sheet take it out. State of capital liabilities or yes, reserves, accumulated profits, reserves. Sanji correct? Sanji, reserves, accumulated profits. Right? So here, instead of this, we can say we have to consider whether the company has reserves. So we have to consider working capital of the company. Right? So in order to check the solvency test, right? First, we have to consider whether the company is able to pay right debts in its ordinary course of business. It refers to working capital. Working capital is good, right? Able to pay debts when it's okay. First condition is full. And the second one is, right, the value of the total asset is greater than stated capital and liability. It means we have to check whether the company has reserves. That is the second condition. So if these two conditions are fulfilled, then company is able to meet the solvency test. Then company can make this private company. It is regarding to the private companies. This private company by unanimous agreement can engage into any transaction, even if the transaction is not compliant with the provisions contained in the article. Right? So here, all the shareholders must sign an agreement in writing. That is the meaning of unanimous agreement. So by way of unanimous agreement, private company can engage into any transaction. Right? However, this capacity is limited only to solvency test. Company must be able to be in the solvency test. Any transaction by the second. Understand the solvency test. We famous question in paper. Solvency test we have checked two things. One is working capital. Right? But the company act does not say working capital. It says right whether we have to check whether the company is able to pay debts in its ordinary course of business. Because to working capital. So that means one is working capital, reserves, all working capital. Second one is total assets. Like value of the total assets is greater than stable capital and liabilities. Because to reserves. We have to check whether the company has working capital and reserves. If these two conditions are fulfilled, company able to be solvency test. Right, so very interesting. Understood. Right, so there is in regard to the private now. Public companies, we have, we can divide into two. Right? Listed and unlisted. Listed means that they can trade their shares on stock exchange. Listed, they cannot trade their shares. Right? Public means actually public companies, they can invite public to purchase share by way of prospectus. They can invite. Right? There are the unlimited companies, the shareholders' liability is unlimited. That's a part of a partner. Right? Own of a sole proprietorship. The liability is unlimited. That is the unlimited liability. Then there are another type, a company limited by guarantee. They don't have share capital. They cannot issue shares, right? When we are considering the articles of association, that topic we mentioned, section 13. Section 13 says a company may set out the articles of association. But if it is a company limited by guarantee, it says the company shall. That is the word. Instead of may. Section 33. Section 33 says. Section 30. Section 13 says the company may set out objects, right? Rights and obligations of the shareholders, right? Provisions with regard to management and administration. So, like, that's may, the may set out. May set out. But section 33 or 34. It says if it is a company limited by guarantee, this company shall mention its objects in the articles of association. Shall mention. Therefore, this is mandated. Shall mention the objects. May means optional. Company can mention its objects or company can avoid from mentioning its objects. We have discussed this on the articles of association. Either it says may shall, section 30, shall mention its objects. If it is a company limited by guarantee. Right. Therefore, it is mandated requirement. Compulsory. Mandated, right? Right. Now, it is a company limited by guarantee, right? This company shall mention its objects. The reason is, right, if this company able to meet three conditions, right? Three conditions there. Right? If these three conditions able to be, then what happens on the section 33, right? The register of companies, right, can authorize the company be registered as a limited company. Limited company. Right? But limited liability company. But without addition of the word limited in its name. Without addition of the word, right? In its name. Understood. Right. If this company is able to satisfy these three conditions, then by a license, register, right, directs the company be registered as a company limited by guarantee. Right. Right. This company need not to mention the word limit, right, in its name. Right. But in other companies, they have to mention the word limited in its name. Yeah, still here. When we are discussing, later on I will discuss regarding the name of the company. Actually, if it is a limited liability company, we have mentioned the word limited. There is a requirement. Section 6 of the Companies Act. Section 6, according to Section 6, we have to mention the word limited. It's a short form of the limited. Right? We have to mention the word limited. We are mentioning the name of the company. Right? Here, the special privilege is granted to this company by the register of companies. But in order to grant this license, these three conditions to be fulfilled. Okay. Register directs the company be registered as a limited liability company, but without addition of the word limited in its name. They will need on to mention the word limited in its name. Privilege. Right? Granted to this company listed by guarantees. Okay. By section 33 of the Companies Act. Right? What are the conditions to be fulfilled? We can identify. What are the conditions? The reason you can identify after considering these three conditions, right? The first one is the object of the company is useful subject to the community. First, we have to consider about the objects of the company. Objects are useful subjects. Useful subject to the community. Like promoting science, art, religion, charity, useful subject to the community. First, we'll consider about the objects. What is the object of the company? Whether it is useful subject to the community or not. Then, according to the articles of association, this company cannot pay dividend to its members. Cannot pay dividend. Its members cannot pay dividends. That is according to the articles. And the third condition is all the income and profit. Income and profit are utilized to promote the objects of the company. Promote the objects. Right, so these are the three conditions to be fulfilled. Then register of companies, right? Directs the company be registered as a company limited by guarantee. Right? Without addition of the word limited Right? The word limited in its name is the privilege granted to this company limited by Galle.
Within the company.
The object of the company we have considered, whether it is used for object to the community or not. And according to the articles, we have registered, we consider about the articles of association. According to the articles, they cannot pay any dividend to its parents. Right? Unable to pay dividends. Right? And all the income profits, they are right. They are utilized to promote the objects. They are used to promote the objects. Okay? Register with, right? Grant a license to this company, incorporated. Incorporated as a company limited by guarantee, but without any without addition of the word limited in its name. They need not to mention the they need not to mention the word limited in its name. Right? Need not mention the word limited in its name. So this is in regard to the company limited by guarantee, special privilege granted to the company. Only they need not to mention the word limited in its name. Need not to mention. Now when we consider Colombo Stock Exchange, Colombo Stock Exchange, it's a company limited by guarantee. Lanka stock case. We cannot identify limited, LTG, limited or LTG in its name. Right? Another example is Central Depository System. It is a fully owned subsidiary of the Colombo Stock Exchange. Central Depository System. Central Depository System. Another subsidiary, fully owned subsidiary of the Colombo Stock Exchange. It's a company limited by government. I need not to mention the word limited because they have applied these conditions. Object of the company. A useful subject and protecting the shareholders who are investing in the share market. That's the main objective of the company. Then cannot pay dividends recently. And the whole income profit are utilized to promote the growth. So these conditions are fulfilled. Register directs the company be registered as a company limited by guarantee, but without addition of the word limited. Hospital were limited. Privilege given to the limited. Now suppose if the name of the company is AB, is the company AB. This is a company. Name of the company is AB. Tell me what is the type of this company? There's a particular company by name AB. Tell me what is the type of this company? Yes, sir. AB, EVB, LTD. Tell me what is the type of AB. There are different types we can recognize, right? Basically 5 types, right? Right? AB private limited. What is the type of this company? Private. Private. Private limited. Right? AB limited. What is the type? Sir? Sir? AB, PLC. PLC. What is it? What's the type?
Public.
Public. The part of the so public, yes. Public company. That's correct. Further,
Public limited.
public.
Limited.
Yes, yes, public limited. That's correct.
So they are listed.
Listed. This is a listed. Public, yes, that is correct. Public listed company, portal company. AB limited. What's the type? Yeah, not that. That is to give an example. AB limited. Yes. Again, public. Yes, public. Listed or unlisted? Unlisted. Public, unlisted. Right? Unlisted. Divided into two. Further, divided into two as listed and unlisted. All are public. Public listed, public unlisted. What is this company? AB. AB.
By guarantee. Limited by guarantee.
AB. The company limited by guarantee. Because यहाँ प्रश्न है. So, company limited by guarantee then. आप लोग उठा रही हो. आप उठा रसागा. AB. Betul ni, kalau kita ada sudah. Kalau tahu kan kita ada kian ada. AB limited. AB limited. I told you it's a list, unlisted. Public, unlisted. You know, public, unlisted. Right. Is listed means public. Right? We don't specifically mention public. This is public, unlisted. Right? What else? Another type we can recognize. The company, right, limited by guarantee, no license granted under section 35. They have to mention the word limited. If the license is granted, they need not to mention the word limited. Right? So again, we can say, oh, right, company limited by guarantee, no license under section 33. Right? There are two types, maybe two types. They can burn AB, right? First one.
Limited by guarantee. Provided the license.
That is correct. Limited by guarantee, right? License granted under section. Right? License granted under section. Very good. License granted under section 30. Then they need not to mention the word limited. AB, like Colombo stock exchange. Need not to mention the word limited. What else? I can't pardon. Oh. Yes. Yeah. So we have to refer the different types of companies. What are the companies can be involved? Yes, that is correct. Again, we can identify two options. Like this. AD limited, public unlisted, or company limited by guarantee, no license grant. Private limited is a private company. This one EB is a company limited by guarantee, license granted under section 30. Oh. Yes. I think I'm working on this missing. But the time unlimited cost. If it is an unlimited company, they can't, right? They can't actually mention limited, right? Because unlimited company, right? Unlimited. There are three main types: limited, unlimited, and company limited by unlimited company. Right? Actually, here we can identify two types of company. We can mention their name as AD. One is the company limited by guarantee, license plan, then they need not to mention the limited. Or unlimited company. Unlimited company. They can mention the name as AD. AD. The name of the company. You can't say limited. Limited means liability is limited. Shareholders liability is limited. If the shareholders liability is unlimited, they can't use limited. How they can mention the name of the company? Can't say limits. I go over types right? Private company, listed company, unlisted company, company limited by guarantee. Right? If the license is granted, they need not to mention the word limited. They can mention the name as limited. If the license is not granted, then they have to mention the word limit. Like AD limited. And if it is unlimited company, they have to mention their name as AD. Then it requires that their shareholders liability is unlimited. They cannot use limit. The word limit. Understood? These are types of companies. Shall we mark the evidence?
Yeah, Tatiya. You Tatiya. Makin bukan dan kota itu makin kan wah santai kan makin kan mana
Right. So
Aku beda lagi ya.
And now, the classification. Another way, actually, we can divide the companies. All the companies we can divide into as limited companies and unlimited companies. Limited, unlimited. Limited companies we can divide it as limited by shares, limited by guarantee. Limited by shares, we can divide into private, public, listed, unlisted. Right? This is the classification according to the companies. There are three types of company: limited, unlimited, company limited by guarantee. Yeah, as we discussed, private, public, listed, unlisted. Right? There are the concept of limited liability. We have mentioned here. We have considered this concept from point of view of shareholder. Then different types of companies recognize the main features, like mentioned in this note. And thereafter, there's a question. Looking over how many consider the different types of companies related to this type of question. Right.
Also,
Right. So, with when we consider the question from different types of company, right? So, no, I told you all together we have learned 7 types of companies recognized under the Companies Act. Right? Listed, unlisted, private, limited, unlimited company, and company limited by government. Apart from these types, other 2 types recognized as offshore and overseas companies. Right? Offshore means actually may be incorporated here or abroad, incorporation. Registered as an offshore company under the Companies Act. Because of some privileges granted to the offshore company, tax concessions like that. So they are like registered as offshore companies in Sri Lanka. Right? They are not permitted to do any business transaction in Sri Lanka. So now here, this question is regarding different types of company. Amal demand and demand are going to form a company subject to conditions. Right? The question is to analyze the different types of companies. Different types of companies recognized by Companies Act. And advise which type of companies is suited for the above conditions. You cannot this question. Right? The company, these are the conditions to be put. Right? The company should be incorporated under the Companies Act. Be incorporated under the Companies Act. Then the company will engage in the business of selling pharmaceutical products in Sri Lanka. So business in Sri Lanka. There will be a business in Sri Lanka. The company must have a share capital. And they must have they must be the shareholders of the company. Among them, they must be the shareholders of the company. The ownership of the company must be restricted only among 2 of them. Only between among that. Right? The ownership of the company must be restricted only between Amal and Bima. Amal and Bima want to safeguard their personal assets in the event of future liquidation of the company. They want to protect their personal assets in the event of future liquidation of the company. We have to advise them, right, which type of company is best suited for above conditions. Which type is best suited? How we can answer this type of question? Type of question we can expect from this topic. Types of companies. Like basically, 7 types of companies recognized. 7 types of companies recognized by the company sector. Right? Now, if we consider, we can remove one by one. Right? The first condition is it says the company should be incorporated under the company sector. Then, when we consider these different types of companies, overseas companies, they are not incorporated in Sri Lanka. They incorporated abroad. They are doing business in Sri Lanka. That type of companies are overseas companies. I have it. One line sentence I can you. I can knowledge can be right. Understand? Therefore, right. According to the first condition, according to the first condition, according to the first condition, the future company cannot be. The future company cannot be. An overseas company. An overseas company. Cannot be an overseas company. Cannot be an overseas company. Right? Yeah, overseas company. Right. Next slide, we shall say because overseas companies are incorporated abroad. Are incorporated abroad. But they can do business in Sri Lanka. We are also they are going to do a business of selling pharmaceutical products in Sri Lanka. Like that cannot be incorporated. Overseas companies are incorporated abroad. Then the second condition it says the company will engage in the business of selling pharmaceutical products in Sri Lanka. And which type of company we can remove based on this second condition? Yes, offshore company. Offshore company may be incorporated in Sri Lanka offshore, but they are not permitted to do a business activity in Sri Lanka. Therefore, right, according to second condition, we can remove offshore company. Right. Next slide, right, number 2, we can set right. According to the second condition, the company cannot be an offshore company. An offshore company. Next slide, we can say because an offshore company may be incorporated in Sri Lanka. May be incorporated in Sri Lanka. But cannot do any business. In Sri Lanka. Like that. Next one is the company must have a share capital. And they must have the shareholders of the company. Must have share capital and shareholders. So when we consider now, right, types of companies, some now basically we have divided companies into three, right? Limited, unlimited, and company limited by current. Three types of companies, right? If it is a limited company, whether they have share capital or not, limited company, they have share capital. Unlimited company, can they issue shares? Unlimited company. Now, under limited company, we recognize two types, private and public. They can issue shares. Public company can issue shares to public. Private company, they can issue shares to relatives, right? Private parties, right? Related parties. That's why we name them as private companies. Right? So they can issue shares. If it is an unlimited company, right? Unlimited. Liability is unlimited. Shareholders' liability is unlimited. Can they issue shares? Can they issue shares? They can issue shares. Like unlimited company, they can issue shares. Like only one type of company, they cannot issue shares. That is company limited by guarantee. They cannot issue shares. Therefore, no shareholders. Therefore, the owners are named as members of the company. Just one company can be written. Unlimited company, share, they have share capital. Only thing is liability is unlimited. The shareholders' liability is unlimited as a partners of a partnership. Right? Owner of a sole trade proprietorship. Yeah, limited is unlimited. Therefore, by disposing their personal assets, sacrificing their personal assets, they are responsible to settle the creditors of the company. There is the meaning unlimited. Unlimited liability. But they can issue shares. Right? So we can say the company must have share capital. Right? Number three, according to the third condition, the future company cannot be a company limited by guarantee. Cannot be a company limited by guarantee. Cannot be a company limited by guarantee. Because the company limited by guarantee cannot issue shares. Cannot issue shares. Therefore, they don't have share capital. They don't have share capital. No share capital. They don't have share capital. And shareholders. They cannot issue shares. Right? Therefore, they don't have share capital. And no shareholders. Right. Understand? Right. Then the third condition. The ownership of the company must be restricted only among two of them. Two friends, Amal and Vimal. They wanted to restrict the ownership only between two of them. Then what?
Examples of that company limited by guarantees.
There is the Colombo Stock Exchange.
They don't have share capital.
Yeah. We don't have share capital. Right? The central depository system, they are actually the license also granted. Another one is the Buddhist. The Buddhist company. Another one is again, actually the Buddhist. Again, yes. Oh, yeah, control the TV company, the Buddhist promoting religion. That again, license is granted. It's a company, actually. Company limited by Galle. Because they are right, the main objective is promoting like the useful subject. That is the condition. Useful, promoting art, science, religion, like charity. That type of company that can be incorporated. The company limited by Galle. As a company limited by Galle. We can ask for a license. These Colombo Stock Exchange. These are companies limited by Galle. Now, actually, anyone can incorporate a company as a company limited by guarantee form. Only thing is, in order to grant license under section 33, those conditions, 3 conditions to be fulfilled. Right? Even though these conditions are not fulfilled, they can incorporate company as a company limited by guarantee. Right? Only thing is, they have to mention the word limited. Limited, the word limited, mention its name. That is the requirement. Right? Famous organizations are actually they are promoting, or they are established in order to promote the useful subject to the community. Right? Stock exchange, these, right? So these are companies limited by guarantee. Even at the end of the owner, I think that man really good. Only thing is they have to mention the word limited. Right? Only thing is they have to mention the word limited in this way. Right?
That section 33 for they need to give a proper content. That's section 33.
Section
33. They are giving license for what they are giving license.
What type of?
What is that section 33 saying?
It's saying, right? If these conditions are fulfilled, then registrar can grant a license to this company. What is the license? Be registered as a company limited by guarantee, but need not to mention the word limited in its name. Only thing is they need not to mention the word limited in its name. I think it's a particular privilege granted to that company. But they will enjoy all the right the things given to the limited companies. They will enjoy, and they are responsible to all the liabilities as a limited company. Only thing is they need not to mention the word limited in its name. That is the right only privilege granted to that type of company. So in order to right get this license, they have to satisfy these 3 conditions. Right? Object and unable to pay dividends. There's a restriction payment of dividends, and they have to prove that all the income and profits are utilized to promote it. So the 3 conditions. The privilege actually. Right. Then, yes, now when we consider the 4th part, the healthier capital, that is therefore because of the share capital and shareholders, this company cannot be a company limited by guarantee. So they cannot issue shares. Right? Therefore, no share capital, no shareholders. Right? Then the fourth part, the ownership of the company must be restricted only between two owners. Yes. Then it refers to which type of companies. Which type of company we can remove?
Public.
Public company. Because public company they can, right? They can issue shares to public. Public means general public. Right? So like other than these two parties, right, can be shareholders of the company. Right? Therefore, shall we take up in the according to fourth condition. Right? According to the fourth condition, the company cannot be a public company. Public company cannot be a public company. Next slide we can say because public companies can issue, public companies can issue shares to the public. Shares to the public. Then next condition is Amal and Bimal want to safeguard their personal assets in the event of future liquidation of the company.
Yeah.
Then we can remove unlimited account. I think take down, right? The fifth condition, right? According to the fifth condition, the future company cannot be an unlimited company. Cannot be an unlimited company. Next slide, because in an unlimited company, shareholders. Reason is they can issue shares. Then we can identify shareholders. Unlimited other shareholders. Only members available in companies limited by Galle. No share capital, therefore no shareholders. Right? So shareholders. Right? In an unlimited company, shareholders have an unlimited liability. An unlimited liability. Towards the creditors of the company. Towards the creditors of the company. Right. Next slide, we can say, therefore, by disposing their personal assets, by disposing their personal assets, shareholders are responsible to pay the creditors of the company. Right. Then which the directors of the company. Right. Then which type of companies they suit? Yes. Public companies. Right. Public companies. Right. Then they can say, right, accordingly. The type of company which is best suited for the above conditions. For the above conditions is private company. Private company. Private company. So one by one we can remove. Otherwise we can't answer to this type of question. First we have to focus on the condition. Then according to that condition we can remove particular lines. One by one we can. Otherwise we cannot answer. Right? So I here I come from. And our family. Very incorrect. All the conditions are fulfilled within company limited by Galle is incorporated under the companies. Right? It can engage like pharmaceutical business in Sri Lanka. And the company must have share capital. If it is a private company, they can issue shares, they have share capital and shareholders. Amal and Vimal, they can be shareholders of the company. And ownership is restricted because the company cannot issue shares to public. Public cannot purchase shares. And if the public able to purchase the share, then new companies come to the new shareholders will come to the company. But here, ownership restricted only between Amal and Vimal. Then the fifth one is if it is a company, private company, then it's a limited liability company. Therefore, right, their liability is limited only up to the amount they have invested in the shares of the company. Shareholders' liability is limited. Therefore, they need not to dispose their personal assets in order to settle the creditors of the company. Right? Limited liability company. Therefore, the best suited type is company limited private company, right? The suited company is private company. Right? There is about the types of company. Now, there's a misconception, right? That is, can't we incorporate a company as a company limited by guarantee, right? To make profits. If that object can't be incorporate a company, can't. Right? Only thing is section 33 and 34, right? It will discuss about particular kind of companies limited by guarantee. Right? What is the particular kind? Three conditions. They able to meet three conditions. Right? Then special privilege granted to that type of company by a license. Right? That is, they need not to mention the word limited. That is only the privilege. Right? If these conditions are violated after incorporation, then thereafter the registrar can direct the company to include the word limited in its name. Right? Privilege is cancelled. They have to mention the word limited in its name. That is a privilege. Right? But it doesn't mean a company cannot incorporate it as a company limited by guarantee for business activities. Business activity. It doesn't mean that they can incorporate a company as a company limited by guarantee. But most of the companies limited by guarantee, they are incorporated with the object, right? Useful subject to the community. Promoting science, art, doing it. That is the practical situation. But according to the law, the company can be incorporated as a company limited by guarantee for making profit for business activities. May not be useful subject to community. Doesn't matter. Only thing is, in order to receive the license, we have to satisfy these conditions, three conditions. License is granted. License is actually a privilege. Need not to mention the word. Right. So these are. Another one is I want to correct this one also. But I mean, the offshore here what that's offshore. The person power to hold lands in Sri Lanka. Right. Now, according to section 490 of the Companies Act came to effect in 2007. Right. According to the Companies Act, overseas companies, these are the companies incorporated abroad. They're doing their business in Sri Lanka. Right, doing their business in Sri Lanka. They can hold land in Sri Lanka. Hold land means they can purchase land in Sri Lanka. But after this Companies Act introduced, right, then there's another law introduced to Sri Lanka. It is named as restriction on land. The name of the law is land. Restriction on Act number is 2014, right? In 2014, right? New law introduced, like Land Restriction on Alienation Act. It's a land act, right? With regard to lands in Sri Lanka, right? Land Restriction on Alienation Act. Alienation, right? So according to this act, foreign nationals, foreign people, foreign nationals, foreign companies, and Sri Lankan company which has 50 or more than 50 foreign shareholders. Three types recognized. Foreign nationals, foreign citizens, they cannot purchase, right? They foreign nationals, foreign citizens, right? And foreign companies. That is overseas companies. It refers to overseas companies. And Sri Lankan company, the company incorporated under Companies Act, Sri Lankan company, which has 50 or more than 50% or more than foreign shareholding. Right? They cannot hold land in Sri Lanka. Okay. Yeah. Yes. Cannot hold. Cannot hold land in Sri Lanka. That is the restriction. Land restriction on alienation. They cannot hold land in Sri Lanka. They can lease land right? Lease. They can lease land in Sri Lanka up to 99 years. 99 years. That is the new law introduced by this statute, like Act. Land restriction on alienation. Like for foreign company, overseas company, they cannot hold land in Sri Lanka. Hold is actually the meaning of hold means purchase. They cannot purchase or own land in Sri Lanka. They cannot purchase. Right? Sri Lanka cannot transfer the ownership of the land to foreign nations. Right? They cannot hold. They cannot purchase. They cannot be the owner. But they can be the lessee, lease the land. Only, right? Up to 99 years, they can lease. More than 2 generations, 99 years means, right? They can lease, only lease. They cannot purchase land in Sri Lanka. Then the 2014, this new law introduced. Therefore, this is right now no longer any section 490. Right. So I will discuss that later. Yeah, we have discussed one topic. Those adjacent to corporate. Yeah, basically here discussing about the companies that it's under this topic. Right? We are discussing about some other related statutes to the corporate. Like this act, land restriction on inflation, foreign exchange act, and securities and exchange commission act. There are 3 statutes we will discuss under that topic. So this is no longer very. So at that point we can solve for today.
Team bro, आ रही है, गेम मार रही है, पप्पाई पप्पाई